Good evening, everybody. Welcome to September 27th, 2017 Planning Board meeting. We're going to bring this meeting to order. We're going to start with a prayer and then the oath of allegiance. Silent moment of prayer. Okay. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Adequate notice of this meeting has been provided indicating the time and place of the meeting in accordance with Chapter 231 of the Public Laws of 1975 by advertising a notice in the Star Gazette and express times and by posting a copy on the bulletin board in the municipal building. Let's do a roll call.
Members Correa?
Yep.
Fitzsimmons? Fryer?
Here.
Snyder? Wolf?
Here.
Chairman Kay?
Here.
Vice Chairman Chesky and Chairman Johnson.
Here.
Alternate Fitzgerald, alternate.
First thing on old business is approving the minutes for August 23rd, 2017. I guess my first question would be, were all 5 members at that meeting?
I was.
Yeah.
I was.
I was.
Carlo?
Yeah.
Were you?
Yeah.
Okay. Tom, you?
I was here.
Okay. Then I'll take a motion to approve.
I'll make that motion. Second.
Okay, we'll do, any discussion? Hearing none, let's do a roll call on the...
Members Correa?
Yes.
Fryer?
Yes.
Wolf?
Yes.
Chairman Kay?
Yes.
And Chairman Johnson.
Yes. We have a resolution. I have not looked at it yet. Just take a look. I think this is for the meeting we had last month, right? August 30th, around there?
Yes.
Okay. Just give me a couple minutes to read through real quick.
It's 18 pages.
Might be, yeah.
18 pages.
Now, we're good on the resolution from the 23rd, correct?
You're working on the resolution from the 30th.
Right, but the 23rd one is good to go.
That was done at the meeting of the 30th.
At the meeting of the 30th, okay.
Well, some of you are perusing this resolution. There's only one typo that I picked up. It's on page 14, paragraph 20. It's halfway down. Mr. Rashad indicated that the design should comply with, instead of W8, it should be WB for wheelbase. So that change should be made, but other than that, I don't have any additional corrections or revisions. Will tell you that a significant amount of time was devoted to this resolution. I know that Mr. Ritter and Mr. Sturbins took their time to review it as well.
We were through Exhibit A4, right? That's as far as... There were no other exhibits. We just went through A4.
That's correct.
Okay. Thank you. It's always easier to read it when it's printed versus on the screen. We would take a motion to...
Well, if I could.
Absolutely.
Before the motion, I know Robert's Rules talks about after the second, but it might be worthwhile if I just spoke first. I have a comment, a question, and then a brief statement that I'd like to make. It's obvious Tony spent quite a bit of time on this. I saw that when I read it. It's appreciated, particularly included the discussion on the traffic, and I don't think you said frustration, but I got the, I got the message. I think it's good that it's in there. I'd like to make a quick statement on that in a second. I do have a question. This developer is applying under the redevelopment overlay. He still does not have a financial agreement. And I asked this question before. I'd like to ask it one more time before we pass this. At what point could he actually begin constructing it? He submitted an application for a pad site under the redevelopment overlay. He really doesn't have approval under that yet because he has no financial agreement. It would seem to me that he could proceed with the approval process, but he really can't touch the site until he gets his financial agreement.
Is the 60-day, is that what the 60-day?
No, the financial agreement has to be negotiated. That could take 2 months, it could take 2 years.
Oh, okay.
I don't think he has the authorization to move forward with construction until that agreement is in place. I would, if you'd like, I'll communicate with the township attorney on that issue, but it's not unlike a developer's agreement. They have to have something in place here before they can move forward.
I'll rely on your opinion there. I just bring out, it's a concern of mine. I know he's anxious to get a temporary road out there to bring the trucks in. It's my opinion that he can't move, so.
Well, pardon the pun, but this may be where the rubber meets the road.
Yeah. And just maybe to reinforce, I would like to make a brief statement, if you can indulge me for a second. If you recall, when the hearing concluded on this application, it was time for a vote. The chair called for a vote, and no one made a motion. We had several moments of silence. There was some discussion on what to do next. And at that point, I made the motion to approve the application, noting it was the right thing to do. Second motion followed, and it was approved. I'd like to take a second to explain what I meant by the right thing to do. I don't want that being taken out of context and used against the township, the board, or myself in the future. Did I mean that the proposed development was the best use of the property? No, but that was not the question before the board. The council had incorporated warehousing into the redevelopment ordinance. Council had already designated the applicant as the redeveloper for the site. Planning board had previously approved a general development plan, so the planning board's job did not include revisiting the use or intensity of development. Did I mean that the proposed development could be constructed without adverse impacts? Again, the answer is no. Both myself and other members of the planning board have expressed concerns about the increase in truck traffic on Route 22. However, that issue is under the exclusive jurisdiction of DOT, as you stated in the resolution, Tony. Though I believe there is room for interpretation, both the applicant's traffic expert and the planning board's traffic consultant offered opinions that the applicant was following NJDOT regulations. So what do I mean by the right thing to do? When it rules on site plans and subdivisions, the planning board functions as a quasi-judicial body. Its procedures are similar to those used in a courtroom. Planning board members are expected to rule on applications fairly and dispassionately, basing their decisions on the facts presented during testimony and in conformance with the municipal land use law and municipal ordinances. To do otherwise inevitably results in litigation. In my opinion, the applicant had satisfied the board's requirements for preliminary approval, so I made a motion for approval, feeling that was the right thing to do. I will continue to communicate with NJDOT, hoping to convince them to address our traffic concerns, and I would just like that in the record.
Joe, we have not heard back from New Jersey DOT yet, I'm assuming, at this point.
Well, again, I guess it's been offered that that's not part of this approval, but as a status report, there's a new guy, his name is Sitko, I can't remember his first name. He took over for Debbie Hurt. I spoke with him twice. He was in the process of reviewing the file. Big file.
Yeah.
Debbie left him a lot of files. I said, I'm sure you have a lot of files, but nobody's as big as this one, I'm sure of it. So, that's where it is. He owes me a call.
Okay. That's all we can do at this point.
Yep.
I have a question on your first point, and actually it's a question to Tony too. When you were asking more or less whether or not they could start construction or break ground, do they have to wait to final approval before they can start construction regardless? I mean, it's only preliminary approval. They can't start yet, right?
If they post the requisite fees, yes, they could, but there are, if you look at the resolution, and I did while you were giving your statement, there are probably a dozen things that they need to do before they can commence construction. If that is, I mean, I can go through them if you'd like.
Well, I had read it, and I appreciate the effort, and I said there was permits, this, that, and the other thing. But I'm still concerned, they really don't operate under that redevelopment overlay until they've completed all of the requirements for a full redevelopment agreement, including the financial agreement. So,
well, let's put the shoe on the other foot. Let's assume that they comply with all the conditions in the resolution, but no agreement is in place. They're really then proceeding at their own peril. They really are, because if the agreement is never reached, they've made improvements, I don't know what they can do with them.
but those improvements are non-conforming, because they're not in the underlying zoning. George?
Well,
There's the underlying zoning, and then there's the redevelopment overlay.
yes,
And as a redeveloper, you're eligible for the redevelopment overlay. If you're not the redeveloper,
yeah, it's the...
What are you doing?
It's the base zoning, if you did not come in under the redevelopment plan. I'll defer to Tony on the actual financial agreement. I gotta admit, I wasn't aware that it hadn't been worked out yet.
I don't think I'm sharing any secrets here. It's one of the few things the mayor and I can sit down and agree on. I'll just say he's here and we're someplace else. The difference is significant in what the pilot should be. So he sends us an agreement, he sends us another agreement, he sends us a third agreement. Mayor, correct?
Correct, and you made a verbal statement as to
Well,
how much.
all with the same pilot, that doesn't change. And so the negotiations haven't been productive so far. Is that fair?
That's accurate.
Well, can I make a suggestion? The applicant, I did send Carl Ken a copy of the draft resolution. The only comment I received was the typo he picked up in page 14, paragraph 20. But he could have come tonight. I'm not throwing him under the bus, but nothing prevents this board from reviewing the resolution as it has and making a recommendation that the resolution change. And I think you are free and authorized to do that this evening. So if you would like, I can include yet another condition to the extent it is doubtful in anyone's mind that addresses the failure to reach this agreement and that construction cannot commence prior to an agreement being reached. I think it provides one additional layer of protection.
That would be my objective. If you feel we're on good legal ground there, I'd like to offer that suggestion.
If they don't like it, they can challenge it.
Yeah.
But where are they going? It's a practical matter. So let's see if we can come up with some language. Prior to the commencement of construction, the applicant shall enter into an agreement with the municipality regarding what?
Pilot is the big one, and other financial conditions, I guess we could say. There's timing of the payments and escalation
It'd be
and
better just say, enter
100 things.
the developer's agreement.
Now, that's, I'm going to argue that that's different, George. I mean, everything that goes through here winds up with a developer's agreement.
Yeah.
This is a financial agreement, and it's part of the redevelopment package.
Okay, no, I understand what you're saying. I just thought it was all part of the same package.
The financial agreement by itself is a thing.
Would you call it a financial agreement?
That's what it's been called.
That's what we've been calling it. I think even our attorney's been calling it that.
Okay, a financial, shall enter into a financial agreement with the municipality for the development of this site. I would like to be more specific.
Well, I'm just suggested for, regarding the pilot and other financial matters.
It's mostly the amount of the pilot payment. How that will, what will accrue to the township. And he gave us numbers, and then they changed drastically.
I just want to come up with the right nomenclature. What is I'm not overly familiar with this pilot and what it's called.
Well, it's payment in lieu of taxes, and instead of paying normal property taxes, he pays a lump sum payment in lieu of taxes. It's generally lower than taxes.
It's paid to the municipality only.
Okay, well, why don't we say this then? Prior to the commencement of construction, the applicant shall enter into a pilot agreement with the...
No, financial agreement with respect to...
I still say pilot and other financial matters, because there's credits involved, there's timing, there's other things.
There's other taxes in there. The land tax, I think, is split by the municipality and the county and the school district, but not the buildings part. And I think that part is exclusively to the township in the form of the pilot program, pilot payment. And like Joe said, it's much less than what it is to be a normal tax situation.
So regarding the pilot program or the pilot agreement?
Yeah, proposed pilot agreement.
Agreement?
Yeah, you can call it that. He'll know what it is. I think he even mentioned it in his opening or closing remarks. And
I'll add some catch-all language and other related matters.
It's good enough to use pilot, that's a common...
Everybody uses pilot. The term we've been using is financial agreement.
Yeah. A financial agreement that especially concerns the pilot payment.
That's the biggest part of the financial agreement.
But there's other aspects to it.
Okay. So the final language I've come up with is, prior to the commencement of construction, the applicant shall enter into a financial agreement with the municipality regarding the pilot, and I put in parentheses, payment in lieu of taxes, close parentheses, and other related matters.
Yeah, that would work for me.
Okay?
He'll know what it is.
Everybody all right with that?
I'm comfortable with that.
All right, I will add that as a condition to the resolution. So with that in mind, I think there was a request by the chair for a motion to adopt the resolution, and I would take it that motion would include the typographical change I made that I referenced earlier and this additional condition.
Definitely would include it.
Yes.
Yes.
And if it's appropriate, I'll make that motion.
I'll second it. So,
Any further discussion? No? I think we've beat this one.
thank you, Joe.
Thank you, Joe.
Beth?
Members Korea.
Yes.
Pryor.
Yes?
Wolf.
Yes.
Chairman Kay.
Yeah.
Chairman Johnson.
Yes.
Ron, there was in the packet a notice of dismissal filed in the Stowaway Self-Storage lawsuit against the planning board and Perugia in connection with that application for approval. And this notice of dismissal was quite interesting in that Stowaway dismissed with prejudice its claims against all defendants, including the planning board. Let me give you some background. There was a case management conference a few weeks ago before Judge Miller. And prior to that conference, I had a conversation with Mark Peck, who was then representing Perugia, and I brought to Peck's attention the existence of a case that came out of the appellate division in the last month or so. And oddly enough, I had been before Judge Miller a week before that conference, and I discussed this case that I'll describe to you in just a moment. And the case stands for the proposition, it's a reported decision, that I think the courts are getting tired to a degree of competitors challenging approvals by planning boards and zoning boards just for the sake of slowing competition down. There's not really any legitimate basis. They look to fabricate issues. They look to draw the process out. Even if they can't stop them, developers are unwilling to invest the money necessary to build some of these substantial projects until all appeals have been exhausted. And what the court said I think for the first time, was that a cause of action for tortious interference does exist against persons or entities that without real cause challenge development approvals, and went so far as to say that the law firm that prosecutes any such appeal could also be held responsible. I told Peck about this case, and it wasn't my place to raise the issue during the conference, but Peck did, and put the attorney for Stowaway on notice that his client was considering filing such a counterclaim, not only against Stowaway, but against the Simon Law Group that was advancing this claim on behalf of Stowaway. I don't know this for a fact, but the only logical conclusion I can reach is that this law firm went back to Stowaway and said, not only are we not taking this case, but you're facing exposure if we pursue this and the court concludes that your claims here are without merit. I was around, I guess, in my first tenure, and George, I don't know if it was the planning board or the zoning board, when Stowaway came in for its application. It was many years ago. Mm-hmm. And you'll note that this is Stowaway Self-Storage, Roman numeral 4. The gentleman that owns these companies has several of these, and if I remember, he's involved in some other businesses, and I think he's a very conservative guy. I think he came to the conclusion, it's just supposition on my part, that it was not worth the risk. It was probably something he could not insure against, and he might have difficulty finding a law firm to bring the claim. And I think he thought better of it, and with that, they abandoned this case, and they did so with prejudice. That's what I think happened here. We may never know with certainty, but I think it's a good result. I think I think Perugia worked with us. They responded to the concerns by Larkin. I think the board did an excellent job with that application. I think that it would be a good project for the municipality. But that's what I think behind this notice of dismissal. So you will not need to incur any additional expense for the defense of this matter. And as another aside, which was another very interesting and unique development, Beth, as she always does and as she should do, submitted this lawsuit, the existence of this lawsuit, to the township's insurance carrier. Despite the fact that there was no claim for monetary damages, the carrier agreed to provide a defense and was in the process of doing so. I spoke with the attorney, Dick Cushing, who was assigned to the matter, who I know has been around for a long time and is very well regarded. And he also was shocked that the carrier was picking up the defense, but look, if the municipality can get its insurance carrier to pick up the defense and not have to pay me in similar matters in the future, so be it. I think there was a question raised as to why a defense was not provided in the asphalt litigation, which ended up being quite expensive for the municipality, and I think that Attorney Campbell was looking into that issue.
But we had a different carrier at the time.
And that may be why.
Now we have Chubb. So, they all have these different, insurance companies that join in, and I think it was the fact that we had somebody different.
That may be so. It may be water under the bridge, but that's the whole story with respect to this case. That's all I have.
Thank you for the update. Thank you for the job well done.
Well, it's done.
All right.
I appreciate it.
That's closed.
Yes, that's done.
All right, thank you. It's good to hear. The next order of business, assuming there's no comments on that, right?
No, I just, Tony might have been around years ago. It has to be a decade ago. The new ShopRite down on 31, there was a competing ShopRite. Did the same thing, held that up for years. So I've seen that before, and I'm happy that there's finally, appellate decision on it.
I've also seen, I remember hearing about a case involving a bog turtle that mysteriously appeared at one of these sites that held up construction for a while as well. And I think ultimately it was determined who put that bog turtle there, and it was a competitor, and I think it was a hefty price that was paid in order to resolve that matter.
Wow. The bog turtle mysteriously appears. Next on our agenda is continuing the Highlands and Master Plan reevaluation. It's been a few months, so there's a couple outstanding topics that I think I'm going to let George refresh on a couple of these so we can catch ourselves up and see if we have any more talking points on them.
Yes.
Go through that with some of your people missing. You might just be repeating everything.
Well, I think we could resolve it tonight and get George working on a couple of these areas. Probably only take a couple, 10, 15 minutes, and we should be able to move. So go ahead.
Okay, well, just to summarize where we sort of are, is back in March we started this process. We're looking at 8 different areas of interest in terms of the center ordinance, developing the ordinance for and making recommendations for possible zoning amendments, repeals, that type of thing, to the center area of the township under the Highlands regulations. And we had identified, as I say, about 7 areas of interest. And they were whether or not we should create a public use zone, whether or not to deal with the nonconformities that are located in the RB district, which is a mix of R75 and commercial uses, to include the Piazza tract in the master plan, to recognize the fact that it has been and appears to going to be designated for affordable housing project, whether or not to repeal or replace the planned development overlay district, and also what to do with the AARC district that's located behind the mall that was not included in the Highlands Center, what to do with that since the area lacks available sewer at this time, and not being included in the center makes it virtually impossible to believe that there ever could be or would be sewer in that area. after several hearings, we did draw some conclusions, and I think probably most of you will remember this. There was a decision made that the Planned Development Overlay District, that's the one that includes the ROM district and allows flexibility in mixed-use projects, the recommendation in the revised master plan for the Highlands Center would be to repeal that district, primarily because the largest part of that district is now covered with the redevelopment plan, which is underway. The other area we dealt with was the AARC district behind the mall. It was the board's conclusion that what they'd like to see is have the residential zoning changed back to highway business, and to notify the Highlands that we would like that included in the center designation. As far as the HB Highway Business District, I think the decision there was obviously that the Piazza tract will be included for recommendations to support the change for affordable housing on the Piazza tract. In terms of the outstanding items that we have not yet come to a conclusion on, was whether or not we felt it was appropriate to do a public use district or just leave it the way it is, not do one. That is to say, identify on the zoning map and create a district for basically properties that are controlled by various governmental agencies or the high school, the grade school, that type of thing, identifying them on the map as public uses and establishing some criteria for any future development in those areas. The other aspect of it that was left outstanding, and it's the one that we were specifically asked at the last time we met to make a proposal for the rezoning, was the RB district on Route 22. As you remember, we discussed there that there were many non-conforming lots in the district, in the sense that they did not conform or could not conform to the standards that were written into the district. And so there was discussions of whether we should modify some of those standards so that we would create fewer nonconformities and make it easier for homeowners in particular to, propose improvements to their lots without the need of having to come into the board for variance relief on some of the subjects. And then there was also the discussion of how much of the district, since it is a mixed residential commercial district, whether the commercial part of the district should be further restricted, that is to protect the established residential neighborhoods from further encroachment of commercial, and then also whether or not we would consider requiring a larger lot size for commercial activity to hopefully encourage the commercial users to actually assemble enough ground to actually provide parking and provide an adequate space for them to take place, because the current district is 7,500 square feet, which is essentially a single-family home sitting on a small lot. And so it almost guarantees you get very piecemeal types of commercial development in the area, if not something of a scale of a home-based business in many cases. So the two items that are still out for discussion are the public use. Do we consider creating that or leaving it as it is in the zone? And then what recommendations we might want to do or consider for the RB district. Now, as I said, one of the things that we came away with from our last meeting was to produce a proposed map showing how this, at least from our perspective, my perspective, how we might change the district to better protect the residential districts in the area. And that we prepared a map for. It was given out to the board members, and I know many of you wanted to go out and take a look at the neighborhood and get a sense of what you felt was an appropriate way to look at that neighborhood. And that's really where we are tonight, to come back and discuss really the RB residential area, how we'd like to handle that, or what recommendations we think would be appropriate. And what I've done is just taken a larger, it's over on the easel, put up a large-scale map of what is the current RB district, which is outlined in red on that map, and I think most of you had, at least at one time, had an 11 by 17 drawing of that same map that outlines what the existing RB district is as it relates to Route 22 and Baltimore Avenue, and how we might modify it so that we encapsulate the area where there's a lot of mixed use, a lot of retail, commercial, but where the residential neighborhoods are still stable and not interdispersed, actually give them some protection and take them out of the mixed-use district and place them in the R75 district, which is what abuts everything. And what you can see on the map, at least based on our sense of what was going on out there, the main change in the district line, at least in my thought, would be along Baltimore Avenue. The district actually goes north of Baltimore Avenue, coming out from the mall. The upper part of that site was, those residential homes on the northern side of Baltimore Avenue were zoned as part of the RB district. And it's my thought that that neighborhood's well established. Most of those homes actually front on the side streets. They don't front on Baltimore Avenue in the sense that their driveways, their porches, the entrance to their homes are on the side streets. It made some sense to pull the line down and go down the center line of Baltimore Avenue so that the homes to the north remain part of that residential neighborhood, and the mixed-use zone then continues to the south. That's probably the major change. The only other changes are very minor. Out where your bank is, on Baltimore Avenue, that's split by a zoning line right now. Half the bank is in the RB district, and the other half of the bank is in the residential zone. And it seems to make sense to me to just include the entire bank parcel in the RB district so that it's consistent with the zoning and, quite frankly, the use of the land in that area. The other change is down by the diner. The old, or I should say the RB district, basically ran out, extending across to 7th Street. It included some residential lot on what is otherwise a totally residential street. And our suggestion was to pull it back so that the RB district really only encompasses, I think it's an insurance office, I'm not sure, but there's an insurance office and parking lot.
Jack
right?
Budge. That's our insurance consultant.
Okay, well, good, I'm glad I got it right then. An insurance office is right on the corner, keeping him in the district, but cutting the residential lot out of it. The only other change...
Well, that's his parking in back, though, George.
Yes, and that's included in the RB.
I see, yeah.
It's the residential lot on 7th Street.
Okay, I got you. I see what you're saying.
And then the only other thing we included in the district that is not in it today is on 1st Street, next to the mall. There's a doctor, let me see if I remember right, a doctor's office, parking lot, right in that area, that we thought we might as well incorporate back into the RB district going north on 1st Street. That's essentially the changes in the district line that I thought was a pretty good feel that would still allow the continuing uses in the district to be there, allow some opportunity for expansion, but at the same time provide a little better protection for the residential uses to the north of Baltimore. So anyhow, that's my thought. I'm open to anybody else's thoughts or discussion on that, and
I had quite a bit to say if nobody else does, but I think I'm going to eventually come around very close to your conclusion.
I've got some things too, but you can go first. Sure.
It's one of the oldest neighborhoods in town, and believe it or not, our first master plan was in 1959. It actually predated the municipal land use law. And the zoning and the master plan in 1959 did not extend the highway business zone to Baltimore Street, it came up far south of that. And I don't know why, but somehow between 59 and 76, that line was moved pretty much to its current boundaries. I was around then. I don't know how some of this stuff came in. I don't know why it was moved. Some of the doctor's offices appear to be old homes that have been converted. Dr. Sam's been there forever. If you go on and you read much of the history in the older master plans, some of the goals were to protect the character of the neighborhoods. They recognized the problems occurred when you mixed these types of businesses with residential traffic, parking, and so on. There were a number of reasons to preserve the residential in that area. Going even way back then, the master plans acknowledged the problems with the undersized lots. I don't know why or how. If you go to Guy Street, behind where I live, there's some homes on tiny lots. The Board of Adjustment back then was a lot of people build, and it's part of the character of the neighborhood. You go through there, you'll see brand new homes and older homes that are tiny and have been redone, and it's part of the character of the neighborhood. None of us live there. One of the comments I got from one of the residents was, I'm going to take Jack Buds for an example. They had less a problem with that because it looked like a home and it fit in the neighborhood than they did with a convenience store or something that was just out of character. I sensed that there'd be objection to further encroachment of highway types of businesses on the residential area. Just behind the Hess gas station, George?
Yes.
That is actually business. That lot, that's a gun store.
For some reason, when we did the land use, we actually pulled the commercial off the tax rolls, and for some reason that didn't come up, but that's what my understanding
That's
is.
your friendly neighborhood gun store. You go down and get a quart of milk and a gun.
Well, you have a gun store in the front, you have a body shop in the
The
back.
body shop is across the street, yeah.
No.
That's
Oh, what?
the back.
It's in the back.
That big building, he owns Warren Collision.
No, it doesn't. H&K?
Yeah. Doesn't Santiago own both? But I could be wrong, all right?
No, the one that owned H&K,
Yeah.
that sold, he built a shop behind the gun shop.
All right, so that building is body
It's a
work.
Morton building,
Okay, yeah.
yes.
Somehow I thought that was associated with it. There's a guy, it's commercial, George, that lot, that whole lot.
Yeah.
Yeah, this whole lot right here.
Not that
Yeah, I know.
The gun shop is
I know.
small, and the Morton building houses,
Okay.
stuff.
Oh, H&K.
Yeah.
Yeah, I couldn't tell what the building was behind it, actually living in there.
So, having said that, my own feeling, George, is I think we're on the right track. I think you make the businesses, you have to extend or maintain your highway business where there is highway business. Where there is not, I think that if you want to maintain the character of the neighborhood, you're going to have to protect those residential lots. And I know some of the people down there, I've been there, you'd say, geez, he's only 3 lots from the highway. You go in somebody's house, it's quiet, they've lived there forever, they're happy there. So I think what you've done here is, protected the residential lots. You've extended the highway business where there is business, and I'm okay with that. The one at 5th, I don't recall. Is that the corner of 5th and Baltimore, the northeast corner? What is that, George? Do you remember?
North,
Yeah, I thought that was a residential lot, but, go, north on 5th to Baltimore, and
Yeah.
it's the northeast corner.
Oh, isn't that the bank?
That's the bank parking lot.
Yeah, that's the bank parking lot.
No, the northeast corner.
Oh, that's the other side. That's
The other
that big
side.
gray square. I drove by it tonight, and I can't tell you what it is.
That gray square, isn't that just the open kind of field where they...
No, the one across the street from that, he's got,
Oh,
I'm sorry, no, you're pulling that in, right? You're pulling
Yeah,
that in.
that's in the RB district, the way this would be, and it always has been. That would remain in the RB district. The open lot north of Baltimore.
No, bear with me here a second, maybe I'm confused. The RB, the blue is what you're proposing.
The blue is what we're proposing.
So that lot I'm talking about would be pulled out of the business district.
You're talking about, when you say I see what you're saying, opposite, catacornered from the bank.
Yeah,
Yes, that's
pulled out. So
and
wherever there's a house, you're bringing that into the residential district.
that's correct. Or as a case, if it's a vacant lot, if it's on the same street and faces the residential street, then we pulled it in too.
Yeah.
On the north of Baltimore.
Yeah,
So that really Baltimore, the north becomes residential and south remains the RB district.
right. And you have the child care would still be part of the
The business.
Right,
Right.
yeah.
And residential, then, the other part of this recommendation was to modify, residential still permitted in the RB district, and that would be our intent. It would still be a mixed-use district. The only other part of our recommendation was to modify the bulk standards to make the residential lots a little easier to improve upon, do their thing on if they want, without forcing them to come in for a variance. We had suggested that we might want to, reduce the front yard setback from 25 to 20, side yards from 12 to 10, both from 28 to 20, and the rear yard to 25. Again, to make it easier for them to do things to their lot, keep it residential, and not have to show up in front of our board asking for relief. That was our thought, that it would make it easier for them to maintain and do some minor improvements without triggering variances. And quite frankly, we felt to make it a little more difficult and require assembly for commercial, we were thinking of actually upping the acreage requirement, square footage requirement for commercial uses, to either make somebody assemble something into a little larger parcel, or basically require them to put together a little bit of land holding before they come in here, so they don't pick a small residential lot and want to do something on it.
Well, I think I follow you. If you go to 5th Street and we go south of H&K there's 3 residential lots. You wouldn't want the guy to pick off the one in the middle and put in something crazy. So he'd have to assemble.
He'd have to buy 3 of them or
3 of them
something if he wanted to do something.
Why wouldn't we put those 3 lots between H&K and the Key City Diner in the R75 district?
I was going to ask that same question. If
Right here, George.
Oh, I see what you mean.
pull these 3.
I guess, I'll tell you my logic on it, and you could do it your way too, but I saw them as facing on to 5th, and north of them has all been developed commercially, and to the south of them on 22 is all commercial.
And across the street is commercial.
Yeah, and across the street, because that's where the gun shop is, it isn't commercial. I mean, it isn't residential. I just felt that the character of that street's been pretty much established as a commercial street. We could put them in, there's nothing to say you can't put them in the residential district. I just felt that character on that street was pretty well established as a commercial street. And they're there, they would be permitted to be there. There's nothing that would say that they have to do anything.
Yeah, but if we approve the setbacks and stuff, you
Yes.
would be penalized in them 3 lots because they would still fall under the old ordinance.
They'd get the new setbacks and everything. In other words, the changes we're making to the setbacks is for all the residential.
Okay, all residential.
Right.
Okay.
In the district.
Okay,
So they benefit equally to
all right.
to those regulations. And quite frankly, by tightening the district up, as you can see, the percentage of district now is going to be, I don't know, I'm just eyeballing it here, but I bet we're well above 60% of the district is already commercial, 65%. So the majority of that area already has commercial uses. So that's why I didn't jog them down there. It's just like the 1, 2, 3 residential lots just south of Baltimore on 3rd Street. I didn't go across the corner and get them. The answer is we could. I don't know of anything in the zoning law that would say that you can't, but I felt sort of that Baltimore South was the dividing line between the more highway commercial type uses than the residential neighborhoods. So anyhow, that was my thought, but again, there's nothing hard and fast about that. If the board felt very strongly, the line can jog.
In a way, you're kind of gerrymandering the district a little bit if you do that, but on the other hand, I don't know how the people, most of those are long-term residents. They're established there.
Yeah.
I think they would object to any more business in there, and a lot of these aren't businesses that, it's not like a drugstore or you go down and you pick up, collision shop, a rental shop, a muffler shop, stuff like that. More highway than, community type businesses. So if someone wanted to protect all of the existing residential, I certainly wouldn't object to that.
I guess the argument would be that the new proposed line between the RB and the R75, those 3 properties weren't actually affected. They're still in the same situation they were before, which is in the mixed district, just that they have smaller setbacks to make them more conforming.
Yeah, it'd make it easier.
Those 3 properties are not being penalized in any way. They're still in the same district they were before.
Correct, and what we've done is for those residential properties that we left in, obviously if they want to, the people that are living there today can continue to use them as a residence. The only option they have is in the future, if they went to sell it, they'd have an option to sell it for a business. I will say that if we want to jump across like at 3rd Street, my temptation then would be to include all of 3rd Street, both sides of the street, down to the jug handle, and catch all those residential lots, and then we'd have one non-conforming commercial lot in that district. In other words, carry it down so we get the whole street and protect the 1, 2, 3, 4, 5 homes that are in there. That jug handle, by the way, might come under pressure for redevelopment once you think about getting a new street and everything developed. If the redevelopment area at Ingersoll gets stronger, that might actually become an important intersection for a commercial use at some time. Somebody might start looking at that as a potential site for something.
Somebody's in there now, isn't Deegan Roofing or somebody in that turnaround now?
Well, according to what I have, nobody's in the turnaround except residential. I mean, in the jug handle.
No, but I think this has just happened within the last year and a half.
Oh, okay.
Who's in the cul-de-sac there now, or the turnaround?
I don't know.
Deacon is on the first house before you make the
It
turn.
used to be Mrs. Foley's place.
I don't know
I
yet how
think
you'd have
there's
something.
either roofing or,
Yeah.
I think it's a roofing business in there now.
the traffic there is only gonna get worse. I don't know how you
Yeah.
establish anything meaningful in there, a business.
One correction, George, it's Baltimore Street, not
Yeah.
Avenue. No, you're right on the map, I'm just talking about what you're saying.
Oh, good.
Baltimore Street.
All right.
George, we would keep the Town and Country Pool. That would stay in business, right? That would stay as the,
Which one's Town and Country
they're the
Pool?
lower
School and
right
Avenue
corner.
Way.
They're the one in the red.
Yes, yeah.
They would stay.
Yeah, no, that's left as is
Okay.
in the district, that's correct.
I'm just gonna revisit something Eric said. Going back to Fifth Street, we talked about not penalizing them, and that's probably true, but you got the people on Sixth who could now have a business in their backyard,
Yes, that's true. That's absolutely true.
you know, so.
Like I say, there's no reason we can't jog it. There isn't. I drew cleaner lines, but there's no reason that they
Yeah.
can't jog.
To me, if you get more business down there, it's really not gonna have a meaningful impact on your tax structure. I don't think it's gonna even increase the convenience of the neighborhood. There's just not enough parking and so on. My feeling is the residents would probably want to preserve the residential.
Okay.
That's me.
I know, well,
Yeah.
I have no prejudice against jogging it if that's the sense of the board. I don't have a strong planning reason to tell you why you shouldn't jog it, I guess is the best way to put it.
We have a bare quorum tonight, and,
Right. Right, exactly. I guess my only comment with that, I would have no problem including them in the resident also, but the fact is, if we don't do anything, they could get a commercial and, off of Fifth Street right now.
yeah, but then, if we change it, at least Sixth Street doesn't get a commercial neighbor in back of them.
I mean, they could right now, though.
They could now.
Yeah.
That would
So
stop
if you
it.
jog it, you not only protect the residential, but you protect the people on the next street.
Right, so that would be an advantage to jogging it.
Yeah, and I tell you, some of the folks I talked down there, I mean, if somebody put up a concrete block building and it took in recycled whatever, they would not like that.
Yeah. So is the consensus to jog and take those 3 lots in? Is that the consensus then?
Be my feeling.
I would have a general proposal that, after you correct for the gun store or whatever,
Yep.
we jog as much as we can to protect as much residential as we can.
Okay. I think that we can do that. That's into that district. How about the discussion that we were holding on 3rd Street, the 1, 2, 3 lots on the south side of Baltimore, and actually continuing almost down to the jug handle, because if my land use is right, there are single family that run all the way down to almost to 22 there. 1, 2, 3, it looks like there's 3 single family homes on the east side of 3rd, and then there is one at the corner of Baltimore and 3rd. Do you have a sense that you'd feel comfortable incorporating those, or should we leave that as a commercial block, a potential commercial block? Not that it is.
My feeling is it's so, I don't know, Joe, how you feel, but it's so close to the jug handle and the construction we're about to go through. I don't see much of an advantage of catching those, with our new line.
Okay. Well, okay.
But I want to see if somebody has.
Well, I'm not sure I understood your proposal there. You're
Well,
saying leave
I'm
it as residential?
No, it's just that it wasn't my proposal, but what we're talking
Well,
about.
what Eric was explaining.
Right.
I'm more leaning towards keeping it the way that George shows it, having Baltimore being the split between the residential and mixed use in the 3rd Street area.
Well, I don't know. I just don't see much meaningful commercial in the circle there. There's going to be so much traffic. It's, you're not going to have parking. I don't know. I just see that as pretty messy. And then You got 3 contiguous lots there on Third. I'd even jog that, but my feeling is to protect the residential at this point.
I don't see much change being, like, I think I agree with you, I don't see much change being possible in that area.
These businesses that are going down there are not attractive businesses. They're, block buildings and stuff, and if you had a house that you lived in for 40 years and all of a sudden you got this thing that looked like a Morton building, I don't know how happy you'd be, and I don't know how that helps the town.
So, do you think we have the consensus then to carry it down 3rd Street then, down, picking up those residential lots on both sides of 3rd to the jug handle?
I wouldn't object to it.
Well, that would be my vote.
Yeah, I wouldn't object to that. Honestly, I don't see that possibly changing, whether we include it or not, so I wouldn't object. Would anybody object to that area? Everyone knows the area we're talking about, right?
Yeah, I think absent any kind of grand redevelopment plan for all this, you might as well just, take care of the people who live there. You're not going to do anything new, so to the extent you can, you protect them, right?
Yeah, I don't want to make anything any worse for the people who live there.
If that's what protects the residents, I'm all for it.
Yeah.
All right.
Now the question is, if this jug handle comes in, this is hypothetical, this jug handle comes in, creates an awful lot of more traffic in that area, and you're one of the residents.
We can address it then.
Yeah, you
Like,
can always
if you wanted to sell it,
change it
would it be
later.
harder to sell it in a residential zone if you're stuck kind of like that one right there?
Well, if he had a contract purchaser, he could always come before the Board of Adjustment, ask for use variance, or else we could do something on council.
Okay.
But we don't know what the jug handle's going to look like yet.
No, we don't.
Okay.
So no objections so we're capturing those, it's like 5 or 6 properties there.
Okay, that's good. All right. Any suggestions on modifying the design standards for the homes within the RB? Are we comfortable with reducing the bulk standards slightly to make it a little more easy for the people to...
I am. If you go through there and you read the history, there's so many non-conforming everything.
There's a lot.
If a guy wants to put in a patio and we can help him, fine.
Okay. All right, if everybody's comfortable with that, those are essentially where I am on that district. The last thing we have to talk about here is the public use thing, whether we want to create it or not. Or just leave the zoning alone the way it is now.
Why don't I speak first, just to get my opinion out of the way? I'm not for that one, George. I think if you're in a town like East Brunswick or Old Bridge, where you've set aside a campus and you're going to have the library and a rec center and all, it makes sense. We're not doing anything in terms of land use. We're just drawing, giving designations to lots and making work for draftsmen and guys who write ordinances. So I'm against it myself.
Okay.
Is there a disadvantage to it, Joe, that besides just going through the work effort of it, that...
Why add something that you don't need? Our job here is not to write ordinances, it's to plan. And how does that really change your planning?
That's my question is
You're not.
Is there a difference?
If you had property set aside, 30 acres someplace, and you had a plan that all your municipal facilities were going to go there, I could see that, but everything's existing, we're drawing lines around it and putting it in a municipal zone, and I just don't see the advantage.
George, is there an advantage to it? I try to...
Well, all I'll say is that some towns, and again, I don't know how applicable it is here, but some towns write this so it's very clear that whatever the use is, whether it's a school, a maintenance shed, or a park, it just makes it clear that those people are allowed to develop in those things facilities that are appropriate to and consistent with their charge. In other words, if it's a park, they can put park facilities in. The other thing is that many of these ordinances just stipulate that if for some reason, and let's assume it isn't part of a Green Acres thing because you couldn't do this, but let's assume it's a piece of land that's owned by a governmental agency but not restricted and they decide to sell it. Some towns have ordinances that state what kind of zoning it must go back into. In other words, without council having to change it, it's just that if they would sell something, this would be an X zone, unless they wanted to actually change the zoning, but it would just tell them where it would go. And other towns have done that because occasionally lots get included in parks and that kind of stuff that were inappropriately zoned, so it just tells them what zone it's supposed to be in.
Yeah, but it doesn't even go in one zone. We're going to have things all over town that are going to go into different zones.
Well, the way you can look at that is already, and I'll admit this, in Lopatcong, the tracks are already within their zoning districts, because the zoning district just flows right over top of all of them. So you can argue that whatever the use is, even if it's a park now and being sold, it isn't going anywhere except to the district that overlays it.
I just don't see this priority. I've been here forever and it's never come up.
Well, that's all. I just wanted to get a sense of the board. There's
I
nothing
figured
wrong
I'd
with
get that out of the way and you won't talk.
That's I remember there was just pieces scattered throughout.
Yes.
Right, that really aren't doing a lot right now. It's not adjacent to a park.
No.
Where you can combine it or utilize it for the same purpose. They're just kind of random pieces.
Yeah.
Kind of sitting there.
Well, yeah. The one advantage I will say, and again, it's just a point of view more than anything, is particularly putting a public zone on your permanent parks and that kind of stuff, and actually having them stand out on the map. Makes it clear to people that are buying and selling lots and in a community how they relate to those facilities, because oftentimes people don't realize what is public, what isn't, what's parks, they don't. So that can help too. It just gives more information to who's ever buying or looking at a neighborhood in terms of what's going on. It really doesn't have a lot to do with the use of the tract. It's still a park, but it shows up as a zone district on the map.
I just think with Zillow and Google and driving it would take a moron to drive down the street here and not realize this is a municipal building, so.
Well, no, I'm not arguing with you there. I'm just saying that many of these mappings, when you go through and pull town data maps today, if they don't create a park district or they don't create something to show a park, it won't come up. It'll come up as the zoning district. That's all I'm saying. But it's not a major thing. I'm not trying to beat this into the ground. I'm just...
Well, the areas that we're talking about, it's not like we're trying to get our Lopatcong Park designated as public. I mean, we're already good.
Yeah,
we're already good on it.
You're not changing any planning.
No.
You're just fiddling with
you're just
stuff.
making it more apparent. That's all.
I could go either way on it. So if Joe's saying no, we can just stop talking about it because we don't have enough people for. If we all don't agree, we can't do anything on that anyway. So for now, it's not.
Okay, that's fine. That's good.
Yep.
George, I did want to revisit the area behind the mall there.
Okay.
There's some history there. I guess they put residential there just as a placeholder. If you go back and read these things, they felt that once sewer became available, it makes sense to lump that in with commercial. What did we wind up doing with that?
Well, the recommendation, right now it's zoned for senior citizen housing.
Yeah.
Is what it's zoned for. recommendation here now is to put it back into a commercial designation. And to the same as the mall, essentially. Rezone it back into the same as the mall. And then request that it be put in, and I don't know if the Highlands will accept it or not, but request that the property be put back into the Highlands Center designation. So that, and as we all know, the odds of getting sewer out there is about nil, but the point is that if we don't put it in the center designation, then there's no chance of getting sewer out there.
Well, here's my thought. We got 20,000 gallons under dispute with Pohat. That'll get worked out someday. And if you can come up with a commercial use that's not intensive relative to sewer use, I think we got a shot at it. If you're going to put senior housing in there or something like that, I just don't think the allocation's there. So if we're saying, we said commercial?
Yes, the intent is now to change.
Yeah, of the options, I think that probably makes the most sense.
And at the same time, we'll request that they put it into the center designation,
Yeah.
because without that, the sewer doesn't make any difference. We won't get it.
Yeah, and you know, the mall was a large user of wastewater when it opened. And now you're getting stuff there. The food court's gone. You know, you got guys selling old furniture instead of spas and stuff like that. I mean, it's changing. I got a feel their water use is going down, so I think there's probably a shot at getting something there, enough to serve, you know, a lot of senior units. I don't think so, but maybe some businesses, offices, some of them.
Yeah,
I
because
think it may work.
no matter how we zone it back there, whether it would stay residential or go the way we're suggesting it, we have to ask to put it back in the center, because we can't do any. Either that, or we should zone it for on-site septic disposal. I mean, it's you know what I'm saying? Because
Well, we don't have all the answers yet.
No,
I
we
mean,
don't,
I'm speculating that there may be a shot at getting some sewer there, but not a lot. No,
Now, isn't that one lot?
I believe so.
yes,
And the ownership of that lot changed, and there was the people...
2 years ago.
yeah.
And it's used for agriculture now?
Well, it's. I think it's being I assume it's in the agricultural program for tax exemption, but I don't know that for sure. It's still being mowed and farmed. Let's put it that way.
I mean, is it customary, being that it's one lot and it's one zone, that you should speak with the owners and see what they're envisioning?
Well, I'm sure. Well, the answer is we can talk to them. I mean, they're basically facing the same problem we're dealing with, is that until you get sewer to that property of whatever gallonage, they're not going to go much in any direction. So it really, to me, comes down to what we feel is more appropriate to let them try to get. And I think we'd be doing them if we can get it into the center, we'll be doing them a big favor regardless of how we rezone it, because at least it gives them the opportunity to try. They may not make it, but it gives them an opportunity to try for it. I don't know who owns it in terms of the use. They originally came in with a senior citizen project, but that fell apart. That didn't go anywhere. They submitted but never processed it. So,
Well, I have no reason to change the recommendation there. I'm just kind of walking through it in my head.
I would say that these are the main points of the recommendations that we would like to eventually incorporate into the center plan, which would then be eventually translated to recommendations for ordinances and actually go into the center zoning regulations. If the board is comfortable, we can begin to write those up in a form that would be eventually not only for the board's review and approval, but submitted to the Highlands as part of this process of getting the center zoning put in place. So I guess the next question is are you comfortable enough now to go ahead and start to write this stuff up and pull together a draft And then we have to decide at what point we actually send it up to the Highlands in terms of getting their review in it.
Well, I don't know what the flow chart is, but to me, I mean, ultimately, the council has to pass ordinances. And I don't know if we have to get that detailed. My own feeling is if you could develop this in a descriptive manner with the justification why the recommendations are what they are, it should probably go to council first.
Well, this is the master planning project process, which is the planning board.
No, I understand that.
The
but-
ordinance has nothing to do, I mean, let's put it this way, there's no ordinances that'll come out of this. This is really like amending your master plan, making recommendations, which would then give you the support to develop the zoning ordinances. This will be exactly what you described. It'll be descriptions of what we want to do, but it won't be ordinances. And it's a process then that, well, in this case, the Highlands is involved, but it's a process that the planning board would review and approve with, obviously, with the consensus of the Highlands at some point. And that would be your process. At that point, it can then come back and ordinances can be drawn. They can be drawn here, they can be drawn at council, they can, they can go through the process coming from the top down or the bottom up. So at that point, but this wouldn't involve any actual ordinances. I mean, it'll be the guidelines for which the ordinances will be drafted. And it's really just like an amendment to your master plan is what it is. That you'd have to do for any ordinance change. So anyhow, that's sort of where we are.
Well, I guess I'm going to back up the question again then. I mean, there's an approval process for a master plan amendment, right? You have to have a hearing and so on?
Yes.
Do you have that hearing before you go to the Highlands or after?
Well, personally, I would think that we would draft what we think is appropriate. While we're doing that, and once we get it to a point that the board is comfortable with it, I would forward a draft of that to the Highlands. The planning board itself, though, I think would hold its own public hearing and make any changes or amendments that come out of it as a result of that hearing, which would then be the final document that goes up to the Highlands. Because I think it's important to have the public input on this before we formally request the Highlands to act.
Well, I'm agreeing there.
So, that's...
I think what I'd like to suggest at this point is, yes, draw it up, include the narrative, the descriptive stuff. I recognize it's a planning board process. I think the public should have input. I think the council should see it. And at that point, after you've had at least some preliminary input, short of a hearing and everything, but there's only a couple people here tonight. I know there's people live in Morris Park. There's other people affected. I think we ought to do something informal before it goes to the Highlands.
Oh, I have no problem with that.
So I'm saying, yes, start drawing something up, the narrative and the justification. And we only have half a body tonight anyway.
Yeah, no, I just meant I'll draft the revisions to the master plan, the recommendations to the board's review. That's what they'll be. They'll be draft.
Right, we covered all the talking points.
All the
Well,
talking.
we have the ROM, we have not, but everything else has been covered.
Yes.
And we've made decisions, we voted on every subject matter, so the next thing to do would be to see it in writing. So that sounds like the logical next step.
Okay. We will do that. And then bring it back to the board. The board can, as a group, can kick it around again.
Yep.
And then we see.
Right, we'll get another look at it.
Yeah, that's what I mean. And also, if these are not that a lot of people pay attention in the public, but as each one of these meetings will give people an opportunity to show up if it's put in the paper and they know that there's discussion going on, even though it's not a formal hearing.
Yeah, let us review it. have the public comment on it before we make a final draft.
Yeah,
it's fine.
Okay.
Just going back to Piazza, that is still part of a litigation, which I think is heading towards a settlement, but it's not fully done yet, so.
George, you said that would be incorporated.
Well, normally I would incorporate that in here to give it, because as part of the settlement, we're going to have to amend the master plan to include Piazza in it. Since Piazza is part of the Highlands Center, yes, the answer is I was going to...
Like, you don't want to write up something that's inconsistent with the settlement either.
Well, this will just say that it's going to be rezoned for affordable housing at a certain number, that's all.
Okay.
It's not going to get into the nitty-gritty of
right.
the thing.
Okay.
I mean, we do have that rough draft ordinance, so we have a sort of a framework to play with anyhow.
All right. All right, thank you, George.
Thank you.
Any discussion from planning board members, things you want to bring up, talk about? We can do that here.
There is a dog.
Concerns. Have we heard anything from the DEA about Mr. Pryor's submission to the DEA that many planning board members have conflicts of interest?
I've heard not a word, but I will say that on an unrelated matter, I have to place a call to the attorney, Deputy Attorney General that provides legal counsel to that body, and I will make an inquiry tomorrow. If I hear anything, I will send a memo to Beth and ask that she circulate it to the board members.
Okay. Also, there was some matter that came up at the council about the terms of planning board members with respect to reappointment. Mr. Fox had originally been appointed by the mayor with a term to expire at the end of 2019. However, he was also a member of the Environmental Commission, which we are required to have to do membership. But his seat there expired in 2017, and the council a couple of years ago said, oh no, he has to have his both his terms expire at the same time. And they chose to use the earlier date.
If I can correct that, I believe you sponsored the resolution, and it's in the minutes, so the council merely pointed out the requirements of the law.
Yeah, we don't have that in the ordinances for some reason, but it is in the state law. But the state law is unclear, as far as I can tell, is if Mr. Fox leaves, and I have to try now to get one person to fill 2 seats, I think I should revert the seat back to the expiration of the December 2019.
Well, that's
And so
not Mr. Spasaro's decision.
Was my decision, right?
The Environmental Commission, there should be one member.
Let's pause. Tony, you...
I have a question. So there should be one member from the Environmental Commission that also sits on the planning board, right? But no more, can't be more than one. And we have right now 0.
Because of a resignation.
Because we have the resignation.
Right, so I'm struggling with how to do that.
Well, I think the township attorney told you how to do that, and that's where you go for advice. But if Tony wants to comment on this, I'm not going to stop him, but...
I can't see any statute that tells me I have to do that. It seems to me I would go back to the way it was, since we made that accommodation because of a particular person who is serving on both.
Tony, you want to comment?
Supposed to...
This is the wrong place for that whole discussion. I mean, that is settled with council.
It isn't, because we're governed by the Land Use Act, and it's the Land Use Act that dictates the various class members, their terms, and who can be appointed and who cannot be appointed to the planning board. And part of the planning board's obligation is to interpret the Land Use Act when called upon to do so. I was alerted to this issue earlier today. I was provided with a copy of the resolution that was adopted by the council. I was also provided with copies of the minutes of that meeting. I looked at the Land Use Act. I also spoke to Katrina Campbell. The appointment that you made of John Fox, Mayor, the appointment that you made originally was modified, and he became the member who simultaneously sat on this board and on the Environmental Commission. That term was to expire the end of this year. He has left, and it is that position that has to be filled. I don't think that you get the opportunity or have the right to retroactively adjust or say that, well, his term was originally to expire on the end of 2019, and as a result you get to appoint someone to fill the slot that he did not occupy when he left the board. I think you have the perfect right under the statute to appoint someone to the Environmental Commission and to this board, and the statute requires and dictates that that is a one-year term, and that term would then, the unfinished term of Mr. Fox would expire at the end of this year. I mean, that is my opinion, and I will tell you that I came to that conclusion before I read the resolution that was adopted by the council, before I read the minutes, before I spoke to Katrina. That was my opinion, and reviewing those matters and speaking with Katrina only reinforced that opinion.
I have a question of sheer curiosity. If you have a member in the Environmental Commission and the Planning Board, but the dates don't coincide, is there one date that trumps the other date as for which one should dictate how they line up?
In my opinion, they have to coincide.
But when they don't, which one do you switch? So I guess hypothetically, if there was somebody in the Environmental Commission right now that took John Fox's spot up here, but in the Environmental Commission it expires in 2018. Now they don't coincide. Which date do you use? Which one trumps the other? Is there?
I believe the December 31, 2017 date would control.
The Planning Board date?
Yes.
Is the one
Control both.
Controls both.
Because that would be the person that is unique to both the Planning Board and the Environmental Commission in that their terms coincide with one another.
Oh, so it may have been done the wrong way then 2 years ago, but I mean
I can't speak to what was done a few years ago.
Past, I know.
But that's my opinion.
Well, I'd even quarrel with the wrong way. What he did is Mark Corral was already on the Environmental Commission, and he appointed John Fox, and we brought that up. I brought it up right away that you can't have two. And we have the resolution that was offered by the mayor, and he recognized that, and he adjusted it to the 2017 date. It had been discussed here, it had been discussed with council. And why the mayor can't research his own records, I don't know, but...
No, I guess my point was, I think
That's not the relevant point, what was done then. It's that gentleman left. And so there is no person whose term expires then. And so, you know, that was only done to accommodate Mr. Fox's particular circumstances. And
The term of a Class 4 member who is also a member of the Environmental Commission shall be for 3 years or terminate at the completion of his term as office as a member of the Environmental Commission, whichever occurs first. And then you go on, it's very clear that if somebody leaves before their term is up, the person appointed is only for the remainder of the
You said the
term.
term would go to the term of the Environmental Commission. So is that...
Which is, you know what, you got an opinion from the township attorney, you got an opinion from the board's attorney. All I ever hear is nonsense from you when you try and read these things, so...
Nonsense, I guess that's what it is.
Well, you got an opinion from two attorneys.
I understand why. All right.
You understand why you think Tony is not being, is being disingenuous?
You're saying that, not I.
I'm asking you, you say you understand?
Well, I think we don't need to talk about it more, but it is, I was intrigued by it because it is an interesting situation where the dates don't line up, and I was kind of curious what everybody
I
thought.
can't go through it now, but if you go through the law, it's covered. And two attorneys came to the same conclusion. And it's backed up by what was done at council with the mayor's motion. And now he wants to undo it, and that doesn't surprise me.
Well, I guess if we have somebody from the Environmental Commission that steps up, we can figure it out then, because
It's figured out, so...
So then that person from the Environmental Commission, who's supposed to be on the Environmental Commission through 2018, 2019...
He serves the unexpired term on the planning board.
So then both would expire in 2017?
No, I'm not saying that.
Including the...
I'm saying that he fills the unfulfilled term, which expires in 2017. Now, I'm getting into legal stuff that I shouldn't. You've heard from two
I don't understand
attorneys.
what that means. I mean,
You've heard from two
the term
attorneys.
is now reduced on the planning board, on the environmental
Mayor,
board.
you never, you know what?
End this year? That's what you're saying?
You heard it from two attorneys. You want to do something else, do something else.
Well, as much as I'm interested in this subject, I think it goes back to, this is really a mayor issue, not a planning board decision. I'd love to learn more about it, but I'm not going to do it right this second.
What the mayor's trying to do is he's going to, there's new appointments coming up. He's trying to circumvent that now. And he's doing that by just speaking nonsense. Two attorneys who don't really deal with each other have come to the same conclusion independently. I don't know what more anybody wants. This is the same mayor who sued for all kinds of crazy stuff and told he was elected mayor, not king, so end it with that.
Understood. I mean, we have...
And you did very well on that.
I mean, I guess as far as I understand, we have open seats on both. We have empty seats on planning board and environmental. So, anybody who knows anybody who wants to step up and come be a member of either planning board or environmental.
I think we've foreclosed out that possibility. Who's going to step up to serve for 3 months? So, my objective was to get somebody that would, want to do it, but nobody's going to want to do that, so we'll have nobody.
Your
I agree.
objective was to get an appointment that outlasted your term, and that's not going to happen.
How do you know my objective?
All right, we're going to move on.
Can I just
Thank you.
add something, and maybe we can close this? 27 years ago, I was involved in a lawsuit where a lame duck mayor, and this was in Mount Olive Township, through a series of resignations by board members, attempted to extend the terms of individuals that he wanted to appoint. The scheme behind, and the scheme, use the word scheme, not in a pejorative way, but the objective of the Land Use Act, as I read it, is to give a mayor who is newly appointed, if the terms are staggered correctly in accordance with the statute, the right to appoint a majority of the members to the planning board. That really is, as I read it, in my experience, the goal behind the Land Use Act. In the case I was involved in, I was asked by the incoming mayor to file suit and challenge the appointments. I did. Judge Stanton, who was then the assignment judge, looked at the situation, and I presented the court with a chart which showed the appointments and how the new mayor would be deprived of the opportunity that exists under the statute to appoint a majority of the board members when that new mayor is elected. And the judge looked at it. He agreed that the statute was being frustrated and ruled that the individuals who had resigned to be reappointed for longer terms, that they had surrendered their positions, and that the new mayor was indeed entitled to make those appointments. Mayor, I don't know what your objective is. Frankly, I don't really care. But the term that expires for John Fox, the term that he was appointed to ends the end of 2017, and that is the slot that needs to be filled. It's for an unexpired term, no more, no less.
Okay. You say this knowing that originally his term was to expire 2019, and those terms were set up so that we'd have the, staggered term situation.
Understood, but his term was then modified.
It was modified. Yes.
Because he was to serve on the Environmental Commission.
Right.
He then filled that slot. Someone else then was appointed, as I understand it, to fill the slot he previously occupied. That appointment was made. I don't think you get the opportunity to make that appointment again. Again, I'm not playing politics here, I'm just telling you what I think the law provides.
Does the law actually say...
Who was appointed to take his slot?
I don't know. I don't know who was appointed, but there was a slot
On the planning board.
on the planning board with a term that expired in 2019.
Yes.
When John Fox,
that didn't happen.
when his term was changed to 2017,
Mhm.
his slot on the planning board opened up. I don't know if anybody was appointed.
Nobody was appointed.
Well,
we have a full planning board.
We have a full complement of board members, so I don't know how that could be the case.
We have a keeper of the records. It's all recorded. It's been posted for a year.
Nobody was appointed to replace him.
Trust me.
But there's
He was still on the
You know
board.
what, Mayor? You
There's
never get this stuff right.
There was no opening.
We get-
We're still on the board. There's no opening.
Where'd Mark Corral go?
What?
When
Mark Corral was different. He was the vice chairman. He resigned.
He was a Class 4 member.
He was a Class 4 member. And
All the Class 4 members are... we're wasting our time. I make a motion to adjourn.
We're not done yet.
All right.
No motion.
Let him...
Well, I mean, if somebody wants to... there's something else on the agenda. We're not done with our agenda yet.
If anyone wants me to spend more time on this, I will. But
My question was purely, I don't understand. And then now you tell me that's the answer, I'll have to accept it. Continue, please, Eric.
Okay. I know what you're going to bring. I doubt you do. Well, it's on the agenda. You should know what...
Mine's thoughts.
Okay. I want to talk about our reduced set electronic submission.
Yeah, it is on the agenda.
Yeah, exactly.
I know.
So we have the sample, and I'll be honest with you, I don't remember if the sample came from George or Paul.
Paul.
It came from Paul, about a requirement for either doing electronic and/or reduced sets. So when we get the lengthy 30, 40...
I'm going to make it easy for you. All right. I'm not going to recommend the council get involved with CAD. We can do something almost immediately with a reduced set. And if we have to do some down the road, we'll do something. We're not set up to handle CAD, or I don't want to get involved with that right now. We got other things.
Well, it was, just to clear the air, it was PDF, but you know what, if I get a reduced set to look at, that's all I
You'll get a
need.
reduced set, and we'll take care of that.
Okay, so what do we need to do to get the reduced set requirement?
Whatever, I don't know, did I get Paul's thing? Email it to me. We'll have
It's in your agenda packet.
what's that?
It's in your agenda packet tonight. It's from Alamucci's code.
I think we have to amend the
So we'd have to amend the ordinance.
Yeah.
checklist requirements for submission.
Yeah. That would include the checklist and the ordinance.
And do we do that, do we make the recommendation to council from the planning board, or?
I think they have that recommendation, and
Okay.
I'm confident that the council representative can pass on our feelings, and I think it will get done.
I will do that.
Great, thank you, Joe.
Next one.
Excellent, easy, thank you, yeah, that works for me. That is the last thing I have on our agenda, but I'll take a motion to open it up to public comment. I'll make the motion to go to public
You don't
comment.
even need to do that. You don't need
All right, then let's just go to public comment.
Bill Wright, 173 Stonehenge Drive. Eric, would I be correct if I would say we're here to make sure we don't get sued, try to keep everything up and level and all that, right?
Are we here to make, yeah, we don't want to
Right,
get
that's
sued.
what we're trying to do. We don't want to get sued anymore, right?
Yeah.
Okay. Today's resolution, you came in and you said, first time I'm seeing this. Let me read it. How many pages was the resolution?
I heard 18.
18 pages.
I believe I said that there's a difference between looking at on a screen and looking at as a printed version.
You can read 18 pages in 4 minutes and a half.
When I've already looked at it on the computer
You
screen.
told me you first time you saw it. That's what you said.
I later on corrected it and said this is the first time seeing it on paper. It makes a difference.
So you did that
So,
in 4
are you
and a
trying
half
to get us
minutes.
sued?
No, I'm not, okay?
Good.
That's what I'm here to make sure it isn't happening. I'm seeing a lot of things happen, and I want to make sure it doesn't. You second the motion after saying, this is the first time I read it. You're telling me you didn't make that statement?
Did I
Then you
second
second it in, when you second, 8 minutes.
If I seconded it, I seconded it.
And you fully believed you did the right thing tonight?
Absolutely.
No problem, no issue.
Absolutely. I read it at work on the screen and
You'd rather work on a screen.
on a computer screen.
You said you couldn't read it.
No, I said this is the first time I'm seeing it on paper. And I said I actually said
How
there's
small is your screen at work? It's like paper size,
It's pretty
right?
big.
Yeah.
Yeah.
All right, that's all I gotta say.
Perhaps without belaboring the point, I think it is incumbent upon all the board members to review these resolutions in advance of the meeting so that they're prepared to comment on them or vote on them.
I'm good with that. People, they're here to get us, they're gonna get us. And with a statement like that, you're setting up the ball for them to hit a home run. That's all I gotta say.
Understood. And I wouldn't have seconded it if I didn't read it.
All right, well, 4.5 minutes scared me. And
No, I put more than 4.5 minutes in, so you can... be
did
sure.
you really? Well, we can look at the tape.
Absolutely did.
Okay.
I think the chairman's comments may have been inartfully phrased, but I think your point is well taken.
Thank you.
No more public comments? Right? Any other comments from board members? Then we can take a motion to adjourn.
I'll make that motion.
All in favor?
All in favor?